Workplace violence prevention is a critical obligation we all share. Stay tuned for some detailed information about your obligations as a California employer. Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Hello, everyone. I cannot believe how hot it is. We're almost in the middle of June. This is crazy. We're in Sacramento. I wish I were in the North Pole right now where I think it might be cold. Although with climate change or global warming or whatever we're going to call it, maybe not. Anyway, we have an important topic today. I am getting call after call from employers who are confused about Senate Bill 553. Remember, Senate Bill 553 was effective last July 1. It requires employers to do a bunch of things related to workplace violence prevention, right? First of all, you have to have a workplace violence prevention plan. So this actually created a new provision of the Labor Code, Section 6401.9. It outlines the elements of the workplace violence prevention plan you have to have. And it has to be detailed, folks. It cannot be an off-the-shelf thing that you bought from somebody. It has to be something that is tailored to your workplace. You have to give the names of the persons responsible for its implementation. You have to list all of the procedures that you've used to involve employees in developing and implementing the plan. You have to have methods to coordinate implementation of the plan with other employers if that's applicable. For example, if you have a workplace where maybe 3 or 4 employers are setting up shop. You have to have procedures for handling and responding to reports of workplace violence and for protecting employees from retaliation, right? You have to ensure that you've got policies and procedures requiring compliance with your plan by your managers, your supervisors, your staff, etc., and even third parties. There's a number of things that are outlined in the code section that are required as part of this workplace violence prevention plan. And again, once you do it, you just have to reissue it every year to make sure it's updated, okay? And you have to be sure that you're either incorporating it as a standalone section in your written injury and illness prevention program, or you can have it as a totally separate document. We like the idea of putting it with the IIPP. Remember that the relevant code section for that is Title 8 of the California Code of Regulations, Section 3203. Okay, so you've got to have a plan. Now, the other thing you have to do, and by the way, you have to post it and make it available to your employees, okay? You also have to maintain a violent incident log. This is a log where you record all the workplace violence incidents, even if they don't result in injury. So it's different than the regular Cal OSHA requirement that we have for reporting workplace injuries or illnesses. The log has to include information on every workplace violence incident based on employee statements, witness statements, and investigation findings. And it's very specific what is required. Like you have to explain what the exact incident was. Was it a physical attack? Was a weapon involved? Were there threats? Was it sexual assault? Did it involve an animal or another event? So you have to be very careful that when you have this log, that you're recording the right things in a log. For example, okay, you run a grocery store. Somebody comes in to steal from you, and loss protection follows them out and tackles them. The shoplifter fights back, and your employee is injured. That's a workplace violence incident, okay? Because your employee was at their work site, and they were injured or harmed by the virtue of what that shoplifter did. So you have to report those things. Now, you're reporting them on the violent incident log. You don't have to turn them in to anybody unless you're asked for it. You also should make sure that you exclude any personal identifying information that would identify who was involved in an incident. For example, of course, if you have a relatively small work environment, you're going to have people who already know what has happened. But very important to keep track of how you are implementing the plan, how you're enforcing the plan, how you're training on the plan. Now, speaking of training, yes, you do have to do training every single year. This is the question I'm getting a lot right now. Well, we did it last year. Do we have to do it this year? Yes, you're supposed to do it every year. And it has to be what they call effective training. One aspect of that is you have to make sure that the training materials are easy to understand and they match your workers' education, reading skills, and language. Then you have to give them, after that first year that you do the training, you have to provide the training annually thereafter. That is the language from the statute. Now, the training is required to cover a whole bunch of different topics related to your workplace violence prevention plan, including how to get a copy of the plan, how to participate in the development and implementation of the plan. There's a bunch of definitions that come into play in Labor Code Section 6401.9, how to report workplace violence incidents without fear of retaliation, explain what the purpose of the log is, and how to obtain relevant records from the log. So there's a bunch going on here. Now, when there are new or previously unidentified workplace violence hazards that are discovered either by you or employees, but it comes to management's attention, or you make changes to your workplace violence prevention plan, you have to provide additional training on the specific hazard or plan modifications. So I know you're making several changes to this packet this year. It's a very good idea, in my opinion, to get training on this so that it's clear that you guys are doing what you need to be doing to hold up your end of the bargain. If somebody quits before they leave training, that's not your problem. Somebody is injured as they walk out of your training on the way to their car, not your problem. It doesn't matter if it didn't happen right in the street. So there's actually a lot of things for us to think about here. You also have responsibilities in terms of record keeping requirements. So first of all, the workplace violence prevention plan has to be in writing. It has to be easily accessible to your employees, also to authorized representatives like union members and Cal OSHA representatives. The records of the violence hazard identification that I was just talking about, the violent incident log, you have to keep the records for 5 years. Now, if you do training for someone as a remedial measure, for example, training records have to be created and maintained for a minimum of 1 year, not 5 years, okay? Records of workplace violence incident investigations must be maintained for a minimum of 5 years, okay? So there's a lot here. You've got to have your plan. You've got to have a strategy for how everyone is going to get trained on the plan. You've got to make sure you disseminate this policy. And honestly, I would start in November of every year. Just start in November. We'll give you ideas about what we think is important, how to update what's going on in your current plan. And then you don't kick that off until your kid is ready to ride the bike and go do what they need to do. Okay, because otherwise you could find yourself in quite a pickle by not complying with these requirements. So there are some additional resources that I want you to think about. First of all, remember that Cal OSHA has some good information out there about the workplace violence prevention plan, about the training, about the workplace violence incident log. Many of you retained us last year to do your training, so we did a video that you could show to everybody during 2024. And then we did your log, we did your plan, all of that. Remember, if you want to use that video again, we have to give you a new license for that. That's a copyright issue. If you want to be able to use the video again for 2025, we're totally cool with that. There are no changes, but you need a new license. We can only do an annual license. We don't charge hardly anything for it, but you do need to get it. So please reach out if you're in that situation. The other thing that is really important, folks, and this comes up with leaves of absence, with managing exempt and non-exempt employees appropriately, making sure people take rest breaks and meal periods, for example, if they're non-exempt. You've got to have somebody in your organization who is committed to compliance with this program. This workplace violence prevention program has been around for a long time. They didn't really come up with these new provisions for a while. And in fact, it wasn't until SB 553 was passed in 2023 for a July 1, 2024 effective date, that we all started realizing, okay, how different things need to be and the changes that need to be done. So there already have been a lot of changes to the law in this area, but you want to think about it from an insider. What do your policies say? What do your procedures say? Do you have everything all kind of worked out? Because if you don't have someone responsible for all of this stuff, or two people at max, they have to have the laboring oar. They have to be doing most of the work. But it's great to have everybody around to support them and to make sure that they are really clear about what the obligations are for the employer. So it's a great idea when you're looking at the workplace violence prevention plan and the log and the training to think about who in your organization would be the best person for that. Who can you tap to make sure that you've got some compliance? Now, many of you have return to work officers, you have workplace violence prevention officers. Those are the key people to have, okay? You definitely need to have somebody who has a good relationship with your staff, who's on the ground when everybody else is on the ground. So whoever's taking this role, who's ever taking the initiative to ensure compliance with this law, they've got to be somebody visible. They have to be somebody on location. They have to be somebody who you can rely on to keep up with the law, make sure that everybody is participating in the training, making sure the log is being printed out, being available to answer questions. Now, are there some unanswered questions? Yeah, there always are when we get a new rule, right? Or a new court decision. There are some unanswered questions, but generally it's pretty clear what you have to do, okay? Once again, you need the workplace violence prevention plan. You need to have a violent incident log, and then you need to provide the training. And remember, just like with sexual harassment prevention training or EEO training, you have to make sure that your materials are accurate, that they comply with the law as it is at the moment you're doing the training. Okay? Some vendors aren't willing to do that because it takes a while to turn the materials around, but it's very important. You have to make sure that you're updating the materials, that you understand exactly what messages you're trying to convey to your employees. The bottom line is, you guys, there is a lot of workplace violence. If you really read the paper and you search Google and Yahoo and these news sites, you will see every day multiple incidents. And the problem is we're sort of becoming immune to them because we think, well, it could happen, but it won't happen here. Or that's a bad part of town. Or, it's just not going to be something that's going to happen in my neck of the woods. Well, it's just not always the case. So you have to be sure that you are protecting your employees. That is part of what's called the General Duty Clause of OSHA. We also have affirmative obligations in Cal OSHA and also in our labor code, as I mentioned at the beginning of our chat here today. So please be sure you identify someone in your organization who can be responsible for this project. They'll stay on top of it. They'll make sure that everybody is trained every year. And you may as well go by the July 1st deadline because that's when everybody else is doing it. Honestly, that's what I'm hearing because the law became effective July 1. Most people are just running their training year from July 1 to June 30th and making sure that everybody is trained at some point during that time. Okay, I want to thank all of you for joining me here today. Obviously, we need to do everything we can to prevent workplace violence, and these tools are really important. So make sure you've got them in play and that you have somebody on site or locally who knows about the program and who can answer questions. All right, thanks everyone. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.